That moment, right, when you find an official-looking paper on your door, an eviction notice, and that feeling, that unease just washes over you.
Yeah, it's definitely unsettling. It's more than just, a piece of paper asking you to leave. It's really the start of a formal legal process.
And understanding that process is just so crucial.
Absolutely. That notice carries real legal weight. It signals the landlord's intent to end your tenancy, and it kicks off a procedure with specific rules, but also, importantly, specific protections for you, the tenant.
Exactly. So today we're doing a deep dive into eviction notices. We want to explore your rights, break down the legal requirements, basically give you the tools to navigate this.
Right. Think of this as your essential guide. We want you to feel empowered, not panicked if this situation ever arises.
Our goal is pretty straightforward. Equip you with that key knowledge, so if you do get an eviction notice, you understand what it means, what your rights are, and what your potential next steps might be.
And we'll be grounding this in legal principles, focusing on what's most vital for you to know. We'll also touch on resources like the Martinez Law Center in Santa Ana, California, which specializes in tenant rights in these exact situations, unlawful detainer cases. Their website, martinezlawcenter.com, is a great place for tenants needing help.
Okay, great. So, first things first, what is an eviction notice, fundamentally? We hear the term all the time, but what's its core purpose?
Well, at its heart, it's a formal, written document. It's your landlord officially stating they intend to terminate your lease or rental agreement.
So it's a legal warning.
Exactly. It serves as that legal warning. It should specify why they believe you violated the agreement, and it sets a deadline to either fix the problem or move out.
It ensures you're formally told about the issue, gives you a chance to respond.
Precisely. It's about formal notification and opportunity.
Okay, so it can't just come out of the blue. There have to be reasons. What are the usual triggers? Why do landlords issue these notices?
By far, the most common reason is failing to pay rent. Either not paying on time, or maybe not paying the full amount that's due under the lease. That's number one.
Makes sense. What else?
Other common reasons involve violating specific lease terms. Things like having pets when the lease says no pets allowed, or subletting your place without permission.
Or causing significant damage, maybe? Beyond normal wear and tear?
Yes, exactly. Substantial damage is another one. Also, sometimes it's simply the end of a fixed-term lease.
Ah, so if you have a 1-year lease and it's up.
Right. The landlord isn't always obligated to renew it. When it expires, they can issue a notice to quit, saying you need to move out. Or they might need the property for their own use, or perhaps they're planning to sell it.
Okay, so quite a few different scenarios. Now, I know there isn't just one type of notice. They differ, right? What are the main kinds someone might get, and what do they mean for the tenant?
You're right. The type of notice is critical. It tells you what you need to do and how quickly. Let's start with the pay or quit notice.
Okay, pay or quit. Sounds straightforward.
It is. It's used specifically for overdue rent. Gives you a set period, often it's 3 days, but this can vary by location to either pay the full amount of the back rent owed or move out.
Pay up or get out, essentially.
That's the gist, yes.
Now, you mentioned location matters. For folks listening in California, maybe near Santa Ana, where Martinez Law Center operates, anything specific about this notice?
Yes, definitely. California has a very important rule for pay or quit notices.
Yeah.
The notice can only demand the actual past due rent. It cannot legally include other charges like late fees, utilities, or other costs. Just the rent.
That's a huge detail, so you need to check the amount carefully.
Absolutely crucial. Also, how you count the days is different. In California, for a pay or quit notice, you don't count weekends or court holidays in that notice period.
So a 3-day notice given on a Friday?
Would likely start counting the following Monday, assuming it's not a holiday. It gives you a bit more breathing room, potentially.
Okay, that's really good to know. What's the next step?
Next up is the cure or quit notice. This one's for lease violations that can actually be fixed or cured.
Like the examples you gave earlier, the pet or the noise.
Exactly. If you have an unauthorized pet, or maybe you've been causing noise disturbances, a cure or quit notice gives you a specific time frame to fix that violation, get rid of the pet, stop the noise, or again, move out by the deadline.
And the deadline calculation in California, same as pay or quit.
Yes, for cure or quit in California, you also exclude weekends and court holidays when counting the days in the notice period.
Any other California specifics for cure or quit?
Well, sometimes under the Tenant Protection Act, particularly for certain violations, the landlord might actually need to send you a warning letter first. a sort of heads up, giving you a chance to fix things before they can even issue the official cure or quit.
Ah, so you might get a warning before the formal notice even starts the clock. Interesting.
It depends on the situation, but yes, that's a possibility to be aware of. A sudden cure or quit without any prior talk might be worth questioning.
Okay. What about the next one? It sounds pretty final. Unconditional quit notice.
It is. This is the most serious type. An unconditional quit notice demands you move out immediately, period. There's no option offered to fix the problem.
Wow. When are these used?
They're typically reserved for very severe situations. Things like engaging in illegal activity on the property, causing really major irreparable damage, or maybe having a history of repeated serious lease violations even after warnings.
And the deadlines for these, I assume they're handled differently.
You assume correctly. In California, for an unconditional quit notice, you count every single day after you receive it, weekends, holidays, everything. It really highlights the urgency.
Yeah, no ambiguity there. Okay, lastly, what about those notices with longer timelines, like 30, 60, even 90 days? Notices to quit.
Right. These longer notices to quit are generally used to end a tenancy when there isn't a specific lease violation being alleged, often used for month-to-month agreements.
So just deciding not to continue the rental arrangement.
Pretty much. In California, the time frame required usually depends on how long you've lived there. If it's been less than a year, the landlord generally needs to give at least 30 days written notice.
And if you've been there longer?
If you've been a tenant for a year or more, that notice period usually extends to 60 days.
And didn't you mention something about just cause earlier? Does that apply here in California?
Yes, very important point. Under California's Tenant Protection Act, for many tenancies, especially those over a year, the landlord can't just end a month-to-month tenancy for any reason. They usually need a legally recognized reason, a just cause.
So they need a valid justification, not just, I want you out.
In many cases, yes. There are specific allowable just cause reasons listed in the law. And it's even stricter for tenants in Section 8 housing in California. They typically require a 90-day notice, and it must state a specific just cause for ending the tenancy. That provides significant extra stability.
Okay, that's a lot to take in about the different notices, especially with those California details. Super helpful. Beyond the notices themselves, what fundamental legal protections should every tenant know they have, like baseline rights?
There are several key ones. Federally, the big one is the Fair Housing Act. This law is crucial. It prohibits discrimination in housing. Landlords cannot evict you based on your race, color, religion, sex, familial status, meaning having kids' national origin, or disability.
So no evicting someone just because they have children or because of their religion?
Absolutely not. That would be illegal discrimination under the Fair Housing Act.
What else?
Then you have state and local laws. These get much more specific. They dictate the exact notice periods required, what counts as a valid reason for eviction in that area, and crucially, the precise legal steps a landlord must follow.
And if the landlord messes up those steps?
If they don't follow the correct legal procedures to the letter, it can sometimes invalidate the entire eviction attempt. Procedural errors matter.
Okay. What about the condition of the place itself? If it's falling apart, does the tenant have any leverage?
Yes, definitely. This ties into something called the warranty of habitability. It's a legal principle, recognized in most places, that requires landlords to keep the property safe, sanitary, and livable.
Livable means things like
Basic essentials: functioning heat, running water, electricity, a sound structure, no major pest infestations, things like that. If there are serious problems affecting habitability, and the landlord doesn't fix them after you've properly notified them,
then what?
then it can potentially be a defense against eviction, especially if the eviction is for non-payment of rent. You might be able to argue you shouldn't have to pay full rent for an unlivable place. It could lead to reduced rent owed or even dismissal of the case in some circumstances.
That's powerful. Tenants have a right to a decent place to live. What if a tenant speaks up about these issues, like reporting code violations or asking for repairs? Can the landlord just evict them for causing trouble?
No, that's generally illegal. It's called retaliatory eviction, and tenants are protected against it. A landlord cannot legally evict you or refuse to renew your lease simply because you exercised a legal right.
Like complaining to the health department or asking for that leaky roof to be fixed.
Exactly. Reporting code violations, requesting necessary repairs, even joining a tenants' rights group, those are protected activities. Evicting someone because they did those things is retaliation, and it's illegal.
Good to know those protections are in place. Okay, let's shift gears. You've received the notice. It's stressful. What are the absolute first things you should do? Step 1.
Step 1, without a doubt, read the notice carefully. Understand exactly why they say they're evicting you, what they want you to pay, fix something, move, and the exact deadline. Don't just glance at it.
Okay, read it thoroughly. Panic might make you want to ignore it, but don't. Then what?
Then immediately check it for legal compliance. Does it have all the required information for your area? Landlord's name and address, dates, the specific reason, the action needed, the time frame, like we discussed with California rent-only rules for pay or quit.
And how it was delivered. Does that matter?
Yes, how it was served matters. Laws often specify how a notice must be delivered personally handed to you, posted and mailed, etc. If the notice itself is flawed, or if it wasn't delivered correctly according to local law, that mistake could potentially make the entire notice invalid.
So look for errors. What about just trying to talk to the landlord?
Definitely try. Step 3 is often to communicate with the landlord. See if you can discuss the issue openly. Is a resolution possible? Maybe a payment plan if it's about rent. Try to work something out. And keep records of any communication. Write things down.
Good advice. When does it become time to call in the experts, the legal help?
As soon as possible, really. Seek legal help immediately after receiving the notice. Don't wait until the deadline is looming.
Where can people turn?
Contact nonprofit legal aid societies, local tenant advocacy groups, or find a landlord-tenant lawyer who represents tenants. If you're in Southern California, Orange County, LA, Riverside, San Diego, an organization like the Martinez Law Center, which focuses specifically on tenant rights in unlawful detainer cases, is a great resource. Their website, again, is martinezlawcenter.com. Also, lawhelp.org is a good national resource to find local legal aid options.
Get professional advice tailored to your situation. What's the biggest mistake people make here?
The absolute biggest mistake, as we touched on, is ignoring the notice. Just hoping it goes away, it won't.
What happens if you ignore it?
It can lead to a default judgment against you in court. That means the landlord likely wins automatically because you didn't respond. It severely weakens your position and speeds up the eviction process dramatically. It's much harder to fight back after a default.
Okay, so ignoring it is out. What if you can't fix the issue or reach an agreement? The next step is likely a lawsuit.
Yes. If you don't comply with a notice, or you can't work things out, the landlord's next legal step is usually to file an eviction lawsuit. In California, this lawsuit has a specific name: an unlawful detainer action.
Unlawful detainer, and what happens then?
You'll be formally served with court papers, usually a summons and a complaint. The summons tells you that you're being sued, and critically, it states the deadline by which you must file a formal written response with the court.
And that deadline is usually short?
Very short. Often just 5 days in California, not counting weekends or holidays, after you're served. So you have to act incredibly fast.
That response is your chance to fight back, legally speaking, to raise defenses.
Exactly. Your written response, often called an answer, is where you state your defenses, the legal reasons why the landlord shouldn't win the eviction case. You have to state them clearly and then be ready to prove them in court.
What are some common defenses tenants might raise?
Well, there are quite a few possibilities. You could argue, for example, that you did pay the rent the landlord claims you owe, and you have proof.
Or the habitability issue we discussed.
Yes. The landlord failed to maintain the property, the warranty of habitability defense. You might argue the amount of rent demanded in the notice was wrong, or that the landlord actually refused to accept your rent when you tried to pay.
What else?
You could argue the landlord waited too long to file a lawsuit after the notice expired, or that the landlord is harassing you to try and force you out.
Or that the eviction is retaliation for exercising your rights.
Absolutely. Retaliatory eviction is a key defense. Or maybe you argue you didn't actually do what they claim you did. You didn't violate the lease, or the violation wasn't as bad as they say.
Lots of potential angles, but you need evidence.
You always need evidence to back up your claims in court. And again, the best defenses depend entirely on your specific situation and local laws. This is where having legal counsel, like from Martinez Law Center, if you're in their service area, is so critical. They know how to evaluate your case and present the strongest defenses.
Okay. So you raise defenses, maybe go to court. What if, ultimately, the court rules for the landlord? What happens then?
If the judge rules in the landlord's favor, they will issue a judgment, often called a judgment for possession. This is a court order stating the landlord has the right to get the property back, and it will give you a specific date by which you must move out.
And if you don't leave by that date?
If you don't leave voluntarily, the landlord can take that court order to law enforcement, usually the sheriff's department. The sheriff then has the legal authority to come and physically remove you and your belongings from the property.
That sounds awful. Are there other long-term consequences?
Yes, unfortunately. Having an eviction judgment on your public record can make it significantly harder to find housing in the future. Many landlords check eviction records as part of their screening process.
So the stakes are really high throughout this whole process.
Incredibly high. Which brings us back to why understanding your rights and acting quickly is so vital.
This has been incredibly informative. It really underscores the need for tenants to be proactive and informed if they face an eviction notice.
Absolutely. Time is critical in these situations. Knowing your rights and taking the right steps early on can make a huge difference in the outcome.
And you keep coming back to seeking legal help. Why is that single piece of advice so crucial?
Because landlord-tenant law is complicated. It varies state by state, sometimes even city by city. An experienced tenant rights attorney understands the specific laws in your area, the nuances, the procedures.
They can look at your specific facts.
Exactly. They can give you advice tailored to you. They can spot issues with the notice or the landlord's actions, identify your best defenses, make sure your rights are protected every step of the way, and represent you effectively if it goes to court. It dramatically levels the playing field.
And for those in Southern California again?
For tenants in Orange County, LA, Riverside, or San Diego counties, Martinez Law Center is specifically focused on these unlawful detainer cases, representing tenants. You can find them at martinezlawcenter.com. They really specialize in this area.
So we've covered a lot, giving everyone hopefully a solid foundation. As we wrap up, what's the single most important message you want listeners to take away from this deep dive?
I think the key message is this. While we've covered general principles and important specifics, especially for California, every single eviction situation is unique. The laws apply differently based on the facts. So if you receive an eviction notice, the absolute most important step is to get personalized legal advice from a qualified professional as soon as possible. Don't just rely on general info, get help specific to your case.
Understanding your rights is the starting point, but expert guidance is key to protecting them.
Precisely.
Knowing your rights isn't just about dealing with one notice. It really is about ensuring you get fair treatment and maintain stability in your housing moving forward. Definitely explore the resources we mentioned, like martinezlawcenter.com or lawhelp.org, and please seek help if you need it. Maybe take a moment now to think what stood out most to you from our conversation today. What questions might you still have that you want to look into further?
Call now 714-442-9741. Thank you.